Good morning, and welcome to another episode of Family Matters, the podcast that speaks about all things family law in the Georgia area. Today, we are joined by one of the partners at the law firm Stearns-Montgomery Proctor, Melanie, and she's going to be meeting with us and discussing the division of high assets in a collaborative practice divorce case. Melanie, it's great to have you with us. Before we get started, here's a little bit about Melanie's background. Melanie's colleagues describe her as well-organized, a great listener, and very detail-oriented, with the ability to absorb large amounts of information and documentation and recast it in a way that tells a story that is clear and beneficial to the clients. Clients use words such as tenacious, thorough, patient, empathetic, and incredible in court. With her pedigreed resume, years of family law experience, and the best human and professional characteristics all melded into one tough advocate and concerned and caring counselor, it's no wonder that she's a great fit at this particular law firm. Melanie, it's great to have you with us today. So, Melanie, let's jump straight in. And the first question that I have for you is I wondered if you could give us some insight, please, into how high value assets are typically divided in divorce cases and what factors are considered in determining their distribution.
Well, Brahman, the first thing we have to look at is we have to determine whether an asset is marital or separate. The divorce judge can only divide marital assets, not separate assets. So that's the first thing we have to figure out. We do that by focusing on when the asset was obtained, how it was obtained, if it was purchased, what funds were used for that purchase, and did that asset grow in value during the marriage. That all factors into determining whether this asset is even capable of being divided or not. Then once we figure that out, we have to figure out what the value of the asset is. Sometimes it's really easy. We'll have a bank account that was created during the marriage, and as of the date of divorce, it has X amount of money in it. Those are the easy ones. But when you deal with high asset cases, you usually have much more complex assets than that. And what we usually have to do is focus on when the asset was obtained. We got to figure out the value of the asset at the time obtained and how has it grown throughout the marriage. When it comes to businesses, we have to figure out what is the interest of that spouse in that business. Is it a partnership? Are they just a shareholder? If so, what is the percentage of that share? How is that business valuated? What type of business is it? And when it gets to that level of complexity, you will find that most attorneys rely on a forensic accountant to come in to go ahead and assess that situation, request certain documents that they need to make that assessment, and then provide reports to the attorneys as well as the parties to help them understand the valuation of the marital assets.
And what would you say are some of the more common challenges faced in divorces involving high assets, and how do you effectively address these?
Well, when we have a combination marital asset and separate asset, let's say, for example, a doctor gets married, and prior to marriage, he was in a practice with 3 other doctors. But then he gets married and they build that practice. It just takes off. So the practice had some value prior to marriage, but then the value grew during the marriage. And one of the problems we typically run into is how much of that growth is a separate property of that doctor's spouse and how much of it is marital property capable of being divided. And so that's frequently a challenge that we have to go through to determine what the value is. And then when we have a certain percentage ownership interest in a business, how do we determine what the value of that is? The business usually files a corporate tax return. How do we figure out what the 20% ownership interest is in that business? So that's some of the challenges that we run across frequently.
Okay, thank you. And what are some of the common challenges that are faced in divorces involving high assets, and how can these be effectively addressed?
Well, we have a couple of issues that come up when we're dealing with high assets. One is we've got to determine whether an asset is separate or marital. To do that, we have to figure out when was the asset purchased, how was it purchased, and whether during the marriage it grew in value or not. So that's one of the issues that we have to deal with. Another is how do we do the valuation itself? Different assets, different high value assets are valued in different ways. You value real estate one way, you value a business another way, and then you have investment and stock accounts, which you value differently. We often will use the assistance of a forensic accountant to assist us in helping evaluate things like businesses. We will use appraisers to help us evaluate real estate. And when we have a situation where there's an asset that has a combination of a separate property component and a marital property component, we frequently do have to rely on a forensic accountant to help us figure out how much of that asset is separate and how much of it is marital.
So that would be very beneficial, especially in a divorce situation where you've got a couple facing a divorce and they have a perception on what the value of those assets are. And this brings it down to the bones and levels the playing field and puts everything where it actually needs to be so that you know the numbers that you're working with.
That is absolutely correct, because if a person hasn't gone through a divorce before, they may have certain misconceptions about how assets are defined. A common one we run across is, well, it's in just my name, so it's my asset. And that is absolutely not true. It could still be an asset just in your name, but if it's grown in value during the marriage due to your effort or that of your wife or both of you or your spouse, then it's going to be marital in nature, regardless of whether it's just in your name or not.
Can you provide some examples of alternate dispute resolution methods that are beneficial in high asset divorce cases, like collaborative divorce?
So before I jump into that topic, I want to talk about litigation and the issues we run across with litigation, which makes alternative dispute resolution attractive to couples that are divorcing. So litigation is a very regimented process. It's controlled by law. It's controlled by courts. We have certain deadlines that we must meet. Whether folks are busy or not, they have to show up in court when a judge tells them to show up. Whether they have a certain amount of time to produce documents or not, there are rules that govern when they have to do it, whether it's convenient to them or not. And by focusing on alternative dispute resolution, we can make the litigation more efficient, give the parties more control over how the process is structured, and also hopefully save them a lot of money in attorney's fees, because going to trial in court before a divorce judge is not only emotionally stressful, it's very financially stressful. So that being said, there are three forms of alternative dispute resolution that you will commonly see used in a high asset situation. The most common by far is mediation. In fact, in Georgia, our courts require it in every family law case, including divorce cases. They want you to at least try to mediate and come up with an agreement yourselves before you make a judge schedule a trial for you. Mediation is where a neutral is selected, a person who's been trained as a mediator, usually an attorney. The attorneys for the parties will get together and collaborate and go ahead and pick out who that mediator will be. They will focus, when you have a high asset case, we focus on a mediator who has extensive experience in high asset cases. That's really important for the parties to believe that the mediator understands their situation. So you got to make sure you've got a mediator with that background. Then there's a mediation session that is scheduled. The parties and their attorneys attend. It could last a few hours, a day, or a few days. We all stay at it as long as there's progress towards settling. But that's just settling. That's just an effort to settle in a mediation session. Prior to getting ready for that mediation, the parties and their attorneys would have gone through extensive discovery in order to determine what are the marital assets and what are their values. So we need that information before we even get to mediation. So mediation just sort of gets you at the very end of the process. It helps you settle, but it doesn't help you get ready to settle. The other two possibilities for alternative dispute resolution are arbitration and collaborative practice. Do you have a preference on which one you'd like me to talk about first?
Let's start with arbitration.
Okay. Arbitration basically is an effort to get a judge that's a private judge. The parties will agree. They will say, look, we want to be divorced, but we really don't want to go through the court process with all of its deadlines. And we don't want to have to wait, because you got to remember, the divorce judges, they usually don't only do divorces. They're usually doing felony criminal matters. They have other types of cases as well. And you're just one number in line waiting to get a trial. And you can wait months and months, even a year or more, to get a final trial in Georgia. So if the parties are just not interested in doing that, they want to get this resolved sooner rather than later. They want certainty for themselves and their children if they have them. They can agree to do arbitration. Again, the attorneys for the parties will talk to each other and select an arbitrator who has extensive experience in high assets. Again, that arbitrator is going to act as a judge, which means they have more power than a mediator. A mediator can help you try to settle, but an arbitrator is going to tell you what's going to happen. They're going to make decisions in your case for you. The attorneys work together to pick an arbitrator that has extensive experience and is willing to take on the case. And then that pulls the case out of the courts for a while. It allows the parties to privately go ahead and set deadlines with the assistance of the arbitrator for the exchange of information. If the parties are disputing whether certain information has been produced or should be produced, the arbitrator will resolve those disputes. And the end goal is to be ready for a trial, an arbitration trial in front of the arbitrator, so that the arbitrator can make the decisions that the divorce judge would make if we ended up having a trial in the divorce court. The benefits of arbitration, again, is you can speed up the process usually. The cost of arbitration, though, you do have to pay the arbitrator. They're a private judge. The divorce judge gets paid by the government, but the arbitrator gets paid by the parties. There's also the concern, if you have a party who's not cooperative, how do you punish them when you don't have the power of the court? You don't have the power to do contempt. So when you have a party who's is known to be very difficult, arbitration may not be the right choice for you because you're may want the power of a divorce judge to help you make that party behave. Now, collaborative divorce, a collaborative practice in the realm of divorce, is a different sort of animal. It's like an extended mediation, but it covers everything. It doesn't cover just the settlement part. It covers the getting ready for it. And it provides a lot of support to the parties as they go through this process. Collaborative practice simply means that the parties are very intent on settling. The problem is they don't have the information that they need to settle. They may still have hurt feelings. There may be complicated custody or complicated high asset issues, and they just want support in how they get through that. But they're intent on agreeing to settle. So they're going to gamble. What they're going to do is they're going to say, okay, we want to do collaborative practice. We're going to hire lawyers. Those lawyers are going to work together to select someone to guide us through this process. That's called your facilitator. We may need a custody expert if there are children, and if there's high assets, we're definitely going to need a forensic accountant to be involved. The gamble is this. The parties are so intent on settling that they are going to agree when they decide to do a collaborative divorce that if they cannot settle this case throughout the collaborative divorce process, that they will be unable to hire those attorneys or any of the experts that they use in the collaborative divorce case in a future litigation. So they're basically saying, we're going to commit our money and our resources to this collaborative divorce process because we really want to settle. And we want it so badly that in the event we just can't settle, we take on this risk that we're going to have to hire all new attorneys, all new experts, and have to start from scratch to do a divorce litigation. And that could be a lot of money. But the advantage of collaborative practice is that it's private. It's not in the courts. There's no open hearings where people are coming to watch your proceedings. You are in complete control of the schedule. So if one of the spouses or both of the spouses is very busy and has a very busy travel schedule or something like that, we can work with that in the collaborative practice area in a way that we could not if we were dealing with a Georgia court.
Can you give some insights into how mediation helps in resolving complex financial matters in high asset divorces?
Well, mediation can help anybody solve anything, because basically what we're doing is we're giving the parties an opportunity to meet with a neutral. Again, this is going to be someone who's been selected based on their background of working in mediations with high asset cases. So they have a good fundamental understanding of what's needed to be done in a settlement. So they can help the parties. First of all, they can empathize with them. You have a lot of parties, especially when you have a financial disparity, you may have someone who's very fearful because they don't know what's going to happen with their financial future. The mediator is going to understand that, is going to let that person vent their frustrations and their fear, and also calm them, because they're going to come across as being very knowledgeable about how to handle the situation, along with that person's attorney. Their attorney should also have that level of comfort and that ability to have empathy. And we also can have our forensic experts attend the mediation. So if there's any questions about evaluation, if we have competing experts that have a different valuation for their numbers, the mediator can pull the attorneys out, pull the forensic accountants out, and have a meeting with just them to go over how these numbers were calculated, to see if maybe, even though they disagree, maybe we can find some middle ground for the purposes of trying to discuss settlement that day. So mediation gives us a lot of flexibility to pull in our experts, but we're not in a trial where we have to meet high evidence standards and dealing with thousands of pages of documents. By the time we get to mediation, all that has been fleshed out through the forensic accountants, and we're just trying to do what we need to do to get to a number that the parties may be able to agree on to be done with the case.
It's quite comforting to think of it that way, because I think for anybody entering into a divorce and walking this journey, I think there's so much fear of the unknown, what the final result is going to be, what that final outcome is going to be in the situation, and what their new journey looks like. And so there's a lot of comfort in a process that is so structured, but so gentle at the same time.
Yes, mediation's gentle, and collaborative practice also has an element of being gentle. And arbitration is gentle in the sense that it's not public, but again, that person's going to be forcing a decision on the parties, unlike mediation and collaborative practice, where the parties are negotiating a settlement and choosing the resolution of the case versus having it forced on them.
What are the potential advantages and disadvantages of arbitration as an alternate dispute resolution method in these high asset divorce cases?
So the advantages to arbitration is usually speed. You do not have to, when you do an arbitration, the parties have pretty much figured out that they probably won't settle. Doesn't mean that they won't at the last minute, but they're looking down the road and realizing we're just not going to be able to find the common ground. So we're going to need somebody to make these decisions for us. But we don't want to wait for a divorce judge to do it. We don't want to wait. We also don't want it necessarily public. We have a lot of sensitive financial information, a lot of complex financial information. We don't necessarily want that being done in a courtroom. Anybody in the state of Georgia has a right to walk into a courtroom and listen to a divorce trial. Most people don't spend their days doing that, but still it's not, as a party, you don't really want your business necessarily being handled in public that way. So arbitration allows it to be done in a conference room, or even virtually in some situations if you have a party that travels a lot. Collaborative practice also offers that option as well. But arbitration gives you that privacy, and it also gives you speed. You will likely be able to get to your arbitration sooner than you would be able to get to a divorce trial in Georgia. The disadvantages are that the cost that you do have to pay your arbitrator. You will also have to be prepared for if you have an uncooperative party. The arbitrator, can issue an order maybe saying they're sanctioned money or anything, but they don't have the capacity to do a contempt finding. They don't have the power of the rogue judge to say, if you don't obey my order, I may even get to incarcerate you for a little while till you pay this fee or pay this cost that you were supposed to pay. So you don't have that power in arbitration. So that would be one of the disadvantages.
So could you give us some insight into the role that these financial experts play in these high asset divorce cases, and how important it is to lean on their expertise during the process?
Very vital to have that forensic accountant, because we as attorneys, we may have had the experience of dealing with high asset cases. We can probably take a good guess as to what things the approximate value of things, or we may understand how to calculate them. But we cannot testify. We cannot be that expert providing that evidence. So we have to have that forensic accountant there to provide the evidence. So that's an important role that they play. But also the folks that do this for a living, they do this in divorce cases. They'll do it in business disputes as well. But for those that focus on divorce cases, they're very much aware of the sensitivities involved. They've dealt with parties that are either fearful because they're not the breadwinner and they're worried, or they've dealt with parties they're used to handling all the money themselves and they're worried. They're worried about a business interest possibly being affected by this divorce. And so the forensic accountants are also sensitive to that as well. That being said, they do have a job to do, and there's certain things documents that they will ask for. They'll gently push and then more strongly push for those documents, because there's certain things that they need to have to do certain valuations of certain high value assets.
So the documents and the requirement for those documents, let's spend a little bit of time talking about how discovery works. So what is involved in that process? What can people expect in this process that's called discovery leading up to the next step in their divorce?
So what discovery is, Brahman, is it's the way the parties discover information from each other and from third parties to help determine the value of these assets, determine what the assets are, whether they're marital or not, and what their value is. It could also provide information that's helpful in deciding how to divide them. So once a divorce is filed, or once the parties choose to go through an arbitration or collaborative practice situation, then we hit the discovery period. And there's several ways we get that information. We'll send written questions to each other called interrogatories. We'll send requests for documents to the parties, but we also send it to business interests. Any business entity is likely to get a request. An employer can get a request. Any sort of investment firm or bank or plan administrator for any retirement accounts, they can also get a request. And the point of those requests is to gather information to help us determine what assets are marital, which ones are separate, and what the value of the marital assets are.
Could you give us an example of specific financial documents, the types of financial documents that people can expect will form part of this process, the gathering?
Well, certainly. So for individuals, they will likely have to provide tax returns for several years. Because it's kind of funny, as people near a divorce case and they know it's coming, all of a sudden those folks that were making a lot of money might all of a sudden start to not make as much. And so neither know that a court or an arbitrator or a mediator is going to let you get away with that. They're going to look at several years worth of tax returns. They'll look at bank statements, investment statements, retirement account statements. When it comes to a business, we want the corporate returns. We would want copies of the documents, the articles of incorporation, any partnership agreements, any buy-sell agreements, profit and loss statements. I've seen forensic accountants want the QuickBooks data. They go to that level to try to see what is truly income and what is not, and the information they're gathering is designed to help them determine the value of assets like a business.
Okay, so now let's take a look at a couple that comes into this fully prepared, and they have got a prenuptial agreement in place. How common are prenuptial agreements in these high assets divorce cases, and how do they impact on the division of assets?
They are fairly common, but boy, they should be more common. I'm a big fan of prenuptial agreements. I think people should negotiate them at the beginning of a marriage. It's hard to say that sometimes because you feel as if, oh my goodness, we're admitting at the very beginning of our relationship that this marriage may fail. I look at it the other way. I look at it, you guys are at the beginning of your relationship. You love each other. You're going to be most kindly disposed toward each other at this moment. And so be open to that and be kind to each other in your prenuptial agreement, and hopefully you'll put it away and never use it. But boy, if you have a divorce, it is helpful to have it because it really helps take a lot of that uncertainty away because it defines how things should be evaluated. It defines what is separate and marital because we can use a prenuptial agreement to change the definition of what's separate property and what's marital property. And we can determine how things should be valued. And that gives a lot more certainty to the divorce process. It can reduce the cost of the divorce process. It could reduce the need for a forensic accountant or limit what the forensic accountant has to do. So they're incredibly valuable. And when you have a couple that's getting married and one of them does have high assets, it is very common for that person to receive advice from a financial advisor, family, or just from their own experience, if they've had a prior divorce or not, to go ahead and ask for a prenup. But I never look at it as a admission that the marriage is going to fail. It's just a way to be kind to each other just in case it does.
That's such a great way to look at it because I'm also a firm believer in a prenuptial agreement for that exact reason. You're starting this journey together, and to start it on the right foot and look after each other for the long haul is so important.
Firmly agree with that.
So let's take a look now at some of the key considerations for protecting assets in these high asset divorce cases, especially when one spouse owns a business or has complex investment portfolios.
There's some things you should do beforehand if you can. The first one is that prenup. You could also do a postnup. So it's not uncommon that after a marriage, if they had a prenup or they want to change it, or they didn't do a prenup, and after the marriage, there is either some strife in the marriage, there was some concern that the marriage may end, but the parties decided to keep at it and try again, or just the need came up. You can do a postnuptial. It's very similar to a prenuptial. You again can define what's separate property and define what's marital and go ahead and deal with your high asset situation in that postnup. So that's one thing to do. Another is to be careful. If you get inheritance or you get a gift during the marriage, what you do with that, if it's coming just to that one spouse, is incredibly important. If you take the gift of money, or you take the gift of stock, or you take inheritance of money or stock, and you put it in an account with your spouse's name on it, congratulations, you've turned that into marital property. Every dime of it is now marital. Whereas if you kept it separate in a separate account just in your name, and you didn't put anything else in it but that inheritance or that gift, that would be seen as your separate property that could not be touched in a divorce. So it's real important that if you're concerned about an inheritance or a gift that you received during the marriage, Keep it in your own name. But it's also important that if you keep it in an account in your own name, don't commingle it. That means if there's money that you earn during the marriage from work, or you sell some marital asset and you take the proceeds from that asset and you put it in that account. Any money that goes into that account, which is marital in nature, can contaminate the entire account. So the account now has some separate property from the inheritance and some separate property or some marital property from the additional monies you put in. So the best advice I can give someone who's got a gift or inheritance is keep it in a separate account. Do not put the name of your spouse on it, and do not put anything else in that account. If the marriage is healthy and is ongoing, you can pull money from that account and use it for marital purposes, but just don't put anything back in that account that's marital in nature. Otherwise, you're now dealing with an asset that has both separate property and marital property in it, and it means you're going to have a forensic accountant involved to disentangle all that.
That's such good advice. Wow. You don't think of things like that when you're in those situations, then that inheritance comes in. Wow.
Well, I just wanted to say one other thing about business interests. So you said, what can we do what can a spouse do to protect their assets? There's limits what you can do, once you've started to create something after a divorce. You have a partnership interest that's growing, or you started a business. You can look at how you structure that, especially when you do a partnership. There's ways you can do a buy-sell agreement with your partners, because your partners are not going to want your spouse to be awarded part of the business and where all of a sudden they're working with your spouse. They didn't ask to work with your spouse. That wasn't their deal. And so a lot of times the partners will do a buy-sell agreement, which defines what happens to that asset in the event of a divorce. It says it has to be sold. It has to be offered to the partners. Here's how we're going to determine the sale price. And so that's a way to deal with those types of things. So whenever someone's setting up a business, or they're continuing to grow a business that they may have had before marriage, it's important to take a look at how that business is structured and how that business is, especially if you've got partners or other owners, what's going to happen if one of these folks gets divorced? What's going to happen to the partnership? It's important to contemplate that before somebody gets divorced, not after.
Okay, so I think what I've gathered from this podcast, and I think our viewers will feel the same, is the expertise that you give and the insight you give into areas that the general public doesn't even think about is so valuable. And so can you give us some insights into, from your perspective, how a skilled attorney could help navigate the complexities of these high asset divorce cases so that you can ensure a fair and equitable distribution of assets at the end?
It's important, the best advice I can give is that a party needs to find an attorney who has experience in this area. Just as you saw in this podcast, as you asked questions, I went down several different paths, and that's where a skilled attorney can take you. They've seen it before. They've seen a variety of situations. They ought to be familiar with the various types of assets that you have, so that when they encounter those assets, they understand the consequences. Now, they're not mathematicians and we're not accountants, most of us, but we know enough, having done this often enough, where to go to get the information that we need and what sort of forensic accountants we may need to assist us. But the reason you would want a skilled attorney is that they have the experience in the background to issue spot, to understand where the case needs to go to get you the information you need so that your assets can be fairly divided and appropriately divided. Because again, it's not a matter of dividing each asset in half. It's a matter of dividing them in a way that's fair and equitable and that makes sense given this unfortunate situation of the divorce.